Hi, everyone, and welcome to today's webinar, Federal Tobacco Litigation, What's the Latest? Today, we'll be discussing the latest developments and some of the key lawsuits brought against the FDA by both public health groups and industry. My name is Kyra Hill, and I'm a staff attorney at the Public Health Law Center. We are extremely lucky to have Rachel Bloomekatz joining us today. Rachel is currently a solo practitioner focusing on Supreme Court, appellate, and complex litigation. Her practice draws on extensive appellate experience in both the public and private sectors, as well as insights gained from her clerkships with Justice Stephen Breyer on the US Supreme Court, Chief Justice Margaret Marshall on the Massachusetts Supreme Judicial Court, and Judge Guido Calabrese on the US Court of Appeals for the Second Circuit. Rachel has also argued constitutional issues and complex appeals in state and federal appellate courts nationwide and regularly practices before the US Supreme Court. She has handled cases on a wide range of issues, including class actions, workers' rights, immigrants' rights, juvenile justice, public health, and voter protection. Rachel regularly represents Public Health Law Center, along with other national public health groups on issues including tobacco control, federal regulatory policy, preemption, and the First Amendment. We're really grateful to have Rachel's insight today, so welcome, Rachel. If you're not familiar with the Public Health Law Center, we are a nonprofit legal center housed at Mitchell-Hamlin School of Law in St. Paul, Minnesota, which is on the traditional, ancestral, and contemporary homelands of the Dakota people. Our center consists of attorneys, policy analysts, planners, communication staff, and an amazing administrative team. We work to advance public health through the power of law. We have two main policy teams, one that focuses on commercial tobacco regulation and one that focuses on healthy and culturally competent eating and physical activity. Our commercial tobacco control team has attorneys, policy analysts, and support staff to provide free legal technical assistance to any of you that have joined our webinar today and are interested in or currently working on commercial tobacco control issues. We offer free legal technical assistance to communities, advocates, health departments, and others working on commercial tobacco control around the United States in several ways, through legal research, policy development, implementation, and defense, as well as through a wealth of publications and resources that you can find on our website. We also provide presentations, webinars, and trainings like this one. However, we do not represent clients and we do not lobby. We provide legal technical assistance related to issues at various levels of government, including at the tribal, federal, state, and local levels. The Public Health Law Center believes that everyone deserves to be healthy. At PHLC, we believe that effective policy is equitable policy, especially when it comes to public health. Health equity is at the core of our work. Our goal is policy that improves public health. This means taking into account the social determinants of health, adverse childhood experiences, and inequity in general. We consider it our responsibility to use our legal knowledge to bring justice to public health as we support our partners in reducing health disparities. When all people are healthier, the communities they live in are happier, safer, and more vibrant places. To us, health equity means that everyone has access to the particularized resources they need to improve their own health and maintain healthy outcomes. This means identifying systemic racism, ableism, and other inequities that act as barriers to health. This also requires moving beyond a one-size-fits-all approach, as well as overcoming and removing barriers that infringe on fairness, human rights, and environmental justice. We believe that for policy to be effective, it must be equitable. So today I'm going to start by providing some context for some of the key components of the Federal Tobacco Control Act as they relate to ongoing litigation. Then we'll discuss three main areas of FDA regulation that have been subject to legal challenge: menthol regulation, what is known as the deeming rule, and the graphic warning label rules. We'll leave some time for discussion and then we'll open it up for Q&A. The Family Smoking Prevention and Tobacco Control Act, or the Tobacco Control Act, was passed by Congress and signed by President Obama in 2009. One of the most notorious aspects of the law is the flavored cigarette prohibition. This special rule for cigarettes specifically outlaws a whole host of dessert, fruit, herb, and spice flavors, but it explicitly exempts menthol and tobacco from that list. Another aspect of the Tobacco Control Act that's important for our discussion today is the requirement that FDA periodically reevaluate tobacco product standards, which includes that special rule for cigarettes I just talked about. In other words, the exemption for menthol has to be reevaluated to determine whether it should be changed to reflect new medical, scientific, or technological data. The Tobacco Control Act didn't completely ignore menthol, though. It required the Tobacco Products Scientific Advisory Committee, or TPSAC, a special advisory committee, to study the effect of menthol on public health, including among youth, African Americans, Hispanics, and other racial and ethnic minorities, and required it to issue a report. That report was issued in 2011, and it concluded that the removal of menthol cigarettes from the marketplace would benefit public health in the United States. FDA issued its own report, similarly concluding that menthol poses a health risk above and beyond that already posed by non-menthol cigarettes. Also in 2013, public health groups, including the African American Tobacco Leadership Council and Public Health Law Center, submitted a citizen petition to FDA detailing the public health crisis caused by menthol cigarettes and asked FDA to issue a rule eliminating menthol from the market. Shortly thereafter, FDA issued its first advance notice of proposed rulemaking, which indicated its potential intent to initiate a rulemaking on menthol. But 5 years later, it still hadn't done anything. And in 2018, it issued another ANPRM soliciting feedback on potential action on menthol. As of June 2020, though, FDA still had done nothing at all. So the African American Tobacco Control Leadership Council and Action on Smoking and Health sued. In their lawsuit, the groups raised three main arguments. It's important to just keep in mind that in order to sue an agency, you have to point to some action that the agency took that was arbitrary and capricious or otherwise illegal, or you have to point to something that the agency is required to do by law and failed to do. In that second category, the statute might have a hard and fast deadline, or it might have no deadline, but the agency may have delayed doing whatever it was supposed to do for so long that it becomes unreasonable as a matter of law. So with that, let's look at the claims. The first has to do with FDA's delayed action and hinges upon the tobacco product standard reevaluation provision I talked about earlier. Specifically, the groups argue that FDA has unreasonably delayed its duty to reevaluate the special rule on cigarettes in light of new scientific and medical data. Second, the groups argued that FDA had also unreasonably delayed responding to the public health group citizen petition. While the FDA had acknowledged receipt of the petition, it never substantively responded to the petition. And finally, as an alternative argument, the groups argued that FDA made an affirmative decision to not add menthol to the flavor ban, which was arbitrary and capricious and in violation of the law. In response to the complaint, the government filed a motion to dismiss all the claims except for the petition claim. On November 12th, so exactly 1 week ago, the court issued its ruling on the motion to dismiss. Judge Westmore ruled that the claim alleging unreasonable delay on the part of the agency in determining whether or not to remove menthol from the market could proceed to the next stage of litigation. She dismissed the claim alleging that the agency already made a decision, but this was expected as they were claims that were really alternates to one another. The petition claim was not at issue at this stage in the litigation. Judge Westmore had some really wonderful language in her opinion, so I'll just highlight a couple paragraphs. She wrote, "The court finds the Tobacco Control Act requires that the FDA not only make periodic evaluations, but make a determination of whether to modify the standard, which may include adding menthol cigarettes to the flavor ban." As a reminder, the standard she's talking about here is the special rule for cigarettes in the Tobacco Control Act, which has so far exempted menthol. Another paragraph from her order, taken together, the Tobacco Control Act intends for the FDA to engage in an ongoing process accounting for new information and periodically evaluating the tobacco product standards, including the flavor ban, to determine if the standards should be changed to reflect new data and protect the public health. So what comes next? FDA says it plans to respond to the citizen petition in January, by January 29th of 2021. Presumably that would be either by granting or denying the petition, which would itself be a challengeable action by public health groups. Another step is potentially that the two parties would ask the court to rule on whether the agency has in fact unreasonably delayed its decision to add menthol to the flavor ban. Existing case law sets out the factors the court would consider here, which include a balancing of factors like whether health and human welfare is at stake, whether there are competing agency priorities, and other factors. So all of that is yet to come, and we'll have to see what happens next. What we do know is that no one is giving up in this fight. Another area of FDA regulation that has been subject to litigation is the deeming rule. The Tobacco Control Act originally gave FDA authority to regulate cigarettes, roll your own, smokeless, and cigarette tobacco. But the act also gives FDA the power to deem other products subject to its authority. That's where the deeming rule comes in. Issued in May 2016, the rule brought cigars, e-cigarettes, pipe tobacco, water pipes, and all other tobacco products under FDA authority. There's still a February 15th, 2007 cutoff date for new products though, which means that any products that came on the market after that date have to go through one of FDA's 3 marketing pathways and receive marketing approval. Also important for background is the fact that in 2017, the FDA issued guidance that pushed out the application deadlines for those pathways by 5 years and essentially indefinitely extended the time by which applications had to be submitted. The first significant case I'll discuss is APV FDA. In this case, public health groups sued FDA over that 27 guidance I just mentioned that extended the pre-market review application deadline for new products. The court agreed with public health groups that the agency had gone outside the bounds of what the Tobacco Control Act requires by indefinitely delaying the enforcement deadlines. So it essentially shirked its duty to review new products under the act. As a remedy, the court imposed new deadlines for applications. The first deadline just passed on September 9th of this year, and there will be a new year period during which products with applications are allowed to remain on the market while FDA reviews those applications. So technically, under the court's order, by September 9th of 2021, the only products on the market should be those that have received affirmative marketing orders from FDA. And the second case I want to discuss in the context of the deeming rule is Cigar Association v. FDA. In this case, cigar and pipe tobacco industry and trade associations sued FDA over its regulation of cigars and pipe tobacco in the deeming rule. Remember, the deeming rule asserted FDA's authority over these products, meaning that all the requirements for obtaining marketing approval, and as well as warning labels, minimum legal sales age, and other requirements that the Tobacco Control Act imposes on tobacco products apply to cigars and pipe tobacco. There's a lot going on in this case, but the main points I want to highlight are 2 significant rulings we've seen so far. The first was that the Court of Appeals for the DC Circuit overturned the health warnings as they apply to cigarettes and pipe tobacco. FDA's official stance is that companies can voluntarily apply these warnings if they want, but FDA can't enforce the rule as to these products. And second, the district court suspended pre-market review as it applies to premium cigars. So the court sent the issue back to FDA to determine the appropriate course that premium cigars need to take to market their products. There are a number of issues that have to do with the deeming rule and its treatment of cigars and pipe tobacco that I won't go into right now, but just know that this case is ongoing. So with that, I'm going to turn to our next area of FDA regulation and hand it over to Rachel to talk about graphic warnings.
Awesome. Thanks, Kyra. So much going on in that litigation that you discussed. That's really interesting, and that really the Public Health Law Center, where you are, has really been at the forefront of, and it's always fun to work with you guys, and amicus briefs and other strategy and things like that in those cases. The graphic warnings cases are ongoing now, and the best way to frame and start thinking about these cases is to think about if you've traveled, which quite frankly, I imagine you have not recently. But if in your pre-pandemic travels, you went to any other countries or things like that, you might notice that at a little kiosk or corner store, or things like that, if they're selling tobacco products, that they have these big, kind of gruesome pictures on them, these big warnings. If you travel to Uruguay, where I lived recently, You actually don't even see any tobacco products displayed at stores because they are kept under the counter or somewhere out of sight. But if you do buy them, more than 50% of the pack has an image and a warning on it. This is pretty typical if you're in Europe, really in many places throughout the world. So the first, maybe it's an obvious question, but why would countries do that? Why do people think that it's a good idea? And what the research and the evidence demonstrates from these countries is that by putting on these quite large graphic warnings on the packs of cigarettes, on advertisements, it serves as a reminder to you every single time you go to buy cigarettes, every single time that you start to smoke, for people who are trying to quit. It helps them in that process. For people who are thinking about starting, including youth, right? This is not just an education about the harms, but also a constant reminder of those facts about the harms of smoking and tobacco use, right? If you think about the warnings that we have now in the US on our packs of cigarettes, right? They're pretty small. They're text only. They haven't been updated since 1984. And what we know from the Institute of Medicine and the FDA, which has studied the issue, is that they're totally stale, right? Nobody even notices them anymore. Can you think about where on the package it is? What is exactly it says? Surgeon General's warning somewhere. It's not like what you see in other countries, and pretty much consumers no longer notice it. It just kind of in one ear out the other. Your eyes almost don't even see it, right? So what Congress did in 2009, in that same Tobacco Control Act that Kyra gave us a great overview of, right, is it said, we're gonna be a little bit more like the rest of the world. Our labels are stale, nobody is seeing them. And Congress actually mandated that the FDA design graphic warnings warning consumers about the health effects of tobacco use. And they actually mandated in the TCA itself, it's not something the FDA came up with, they mandated in the act itself that these graphic images had to cover 50% of kind of the front or the back and the back pack of the cigarettes, and had to be 20% of the ad space. There are lots of kind of detailed technical requirements in there, but the idea was that these should be warnings that consumers don't just ignore, that that would really provide education and information to consumers. So what happened? Right? We don't see those pictures on our cigarette packs today. And as many of you know, these have been caught up in litigation for pretty much a decade now. So I'll take you through a little bit of the history of that litigation and where we are now. So let's see, in 2011, if we can go to the next slide, the FDA did come up with its graphic warnings for these particular health advisories that Congress actually set forth that should be on cigarette packs. And the FDA studied this for a while, thought about what would be effective, what would be understood, and things like that. And you can see what they came up with. Take a second to look at these images. One of the things that I don't love about webinars, as opposed to doing things in person, is I can't really ask you, what do you think of these? How do they make you feel? What's your response? Or things like that. But you certainly might think that these are starting to look a lot more like what you see in other countries, what has been proven through science to be an effective part of tobacco control measures and reducing tobacco use in other countries. So after these came out, the tobacco companies sued. And they said, among other things, that requiring them to put these images, these graphic warnings, onto their products was a violation of their First Amendment rights. And particularly, they asserted that these images here, they're not just basic factual warnings like we have to do right now. They're not just the text that says, you know, smoking can cause cancer, or nicotine is addictive. This is actually an ideological message, a controversial message that you are forcing us to carry on our product. And therefore, this violates the First Amendment. And I should say the tobacco companies challenged these warnings in kind of two ways. And this gets into some technical legal speak. Many of you on this call are lawyers, some are not. But there are two challenges. One says, these images, the ones you're looking at right now, these ones in particular violate the First Amendment, called an as applied challenge. But they also just said in general, any images, any graphic warnings that you make us do, given that they have to be this big, they're all gonna violate the First Amendment, no matter what you put on them. Well, the DC Circuit came back and they agreed with the tobacco companies as to the as applied challenge. They said these images, they are not just factual and controversial. They are not like the warnings that are on there now that just give you somewhat unemotional, very textual, very bland kind of just information. How the DC Circuit characterized these warnings was as being essentially mini billboards for the government's message to not smoke. It wasn't just giving information, it was advocating, right? This was ideological. And therefore, it was going to receive what kind of more scrutiny, more of a harder look by the court before we were going to force the tobacco companies to do that. So if you can go to the next slide. The court, if just a warning put on something, if you think about your medication and lots of warnings that you see a lot of places, you know, it might just give you some basic information. And most warnings meet this Zauderer standard, which just says if a warning is factual and non-controversial and it's not unduly burdensome, it's going to be really low level of scrutiny. The court will look at it. Likely it will be okay and not cause a First Amendment problem. But if not, if your message is ideological, it's not just factual and non-controversial, it's unduly burdensome, then you get to this higher level of scrutiny. And the court really was going to want to know, government, do you have to have this warning like this on here, right? Do you know that doing this is really going to help smoking rates, is really going to make it so youth don't start smoking and things like that? And the DC Circuit found that really the evidence was just not there to support satisfying kind of this deeper scrutiny. We call it central Hudson or intermediate scrutiny that is required when a court thinks that your warning label is not just factual and non-controversial. So no, these warning labels that the FDA designed, they're out. What about the facial challenge? Could the FDA ever make a warning label that would be okay? Well, the Sixth Circuit Court of Appeals, which is in my neighborhood in Ohio, but covers some areas in the Midwest and South, said yes, just the fact that you have pictures doesn't make something not factual or make something controversial. Pictures are used to depict facts all the time, right? And even if you're depicting, if you're showing a picture, not exactly how everybody would have a consequence to smoking, not how every single person's lung would look after smoking, or not how every single person would look if they got throat cancer or something like that. But it can still be informational. It can still be factual. Think, and the Sixth Circuit said this, think about Grey's Anatomy, right? Those are very factual depictions. Certainly everybody is not going to have the condition as depicted in that book, but still we certainly call it factual and non-controversial. So the FDA here is now back at the drawing board. These images, not okay, but the whole rule is not is not thrown out. They can still go ahead and do images. Well, that is like 2011 with the first set of images. The FDA, much like on menthol, just sat and sat and sat and did not issue a new attempt at graphic warnings. And a bunch of public health groups, I think some of you who are actually on this call are part of those groups, actually sued the FDA and said, hey, Congress mandated that you do this, right? Congress wanted us to have these, told you to do this. You can't just sit on your hands. It's been too long. And lo and behold, in the process of that litigation, the FDA came out with its new set of graphic images, which we can see here on the next slide. So you can see these new warnings. They are still depicting the health consequences of smoking as required by Congress. They're still 50% of the pack, also required by Congress, or 20% of the advertisement. And I'd be curious, again, if we were in person and talking about this, what do you think of these images, compared to the others? They're not quite so ominous. They don't have those black, dark backgrounds with the smoke coming and things like that. And indeed, the FDA spent a lot of time with scientists, with illustrators, with scientific illustrators, and all sorts of experts to make sure they were really just depicting, what were outcomes of tobacco use. And there's something a little different about these warnings too, these graphic images. The FDA decided that they would focus on consequences of tobacco use that are not as well known, right? So you have warnings here that aren't the ones that Congress originally mentioned in the TCA should go on, but are things that you might not know, right? Did you know that smoking causes cataracts, which can lead to blindness? Well, those of you on this call probably know all of these things because you're public health experts or in this field. But these are not things that are as known to the general public. And indeed, some of these are related to new science about tobacco use and its harms that were really not known before. Things about the relationship between smoking and impotency, right? Or erectile dysfunction, about blood flow, which can lead to amputation. So one of the FDA's aims here was not just to tell you, presumably, well, not presumably, but tell you things you might already know about smoking, but really to educate you about risks of tobacco use that many people in the population are not aware of. So what happens? They put out this new rule. The tobacco companies are like, oh, thank you so much for toning this down. We're now going to agree with all the scientists at the FDA and Congress and understand that we should give people these warnings. Yeah, we have yet another round of litigation that really, quite frankly, looks very much like the original litigation that we saw back in 2012. And you can see in the next slide that we're now really asking the exact same questions again. The FDA, the tobacco companies have two lawsuits challenging these graphic warnings right now. One is in the Eastern District of Texas. I'll let you guess why they decided to sue there. Another lawsuit was filed by Philip Morris. The first one was RJ Reynolds. The second one by Philip Morris, filed in the District Columbia, where many agency lawsuits are filed. And there are a couple claims, but the most prominent claim, as before, is a First Amendment claim. And the tobacco companies really have the same arguments. This is ideology, right? These warning images shock, they disgust. They're not just giving people information. They're not just a warning, but they're there to carry the government's message of what people should do, right? That's advocacy, that's ideology. And therefore, we don't just look at it at this low standard for things that are factual and uncontroversial. Instead, the tobacco companies are urging the court, look at it under these heightened levels of scrutiny. right? Is this really the only way that the FDA can get the general population to learn this information, right? And another argument that they're really pressing this time is they're saying, these warning labels are so big, right? This isn't just a disclosure that we have to make, right? It's not like we've written a long document and then there are lots of disclosures like with your mortgage or things like that that are just added pages. They're saying this is taking our space, right? This is taking the space where we would talk about our brand, that we would advertise, that we would put our speech on, right? So these warning labels, they're not just a disclosure, they're a limitation on our speech. And therefore they necessarily get heightened levels of First Amendment scrutiny, which of course make them more likely to be struck down. And just like in the cases in the past, they're repeating this argument that not only are these warnings, the ones that were released earlier this year, not only are these warning labels impermissible, but they think that no warning label would ever be permissible given the size, given that in their view, it was Congress's whole goal just to send an ideological message about tobacco. These cases right now, again, are pending. All of the briefing on the tobacco companies' motions for preliminary injunctions and summary judgment has already been submitted. The warnings are supposed to go on PACS by June 18th, 2021. And of course, that will all depend on the outcome of these cases.
Awesome. Thank you so much, Rachel, for all of your insight. And I do want to ask you a couple follow-up questions. So you mentioned a little earlier, I think there might be some folks on the call who have participated in various cases as amicus, and you've represented Public Health Law Center in our submitting our amicus briefs, and you've written, actually anyone on the call, if you are really interested in these cases, I would highly recommend reading Rachel's briefs. They're awesome. They do a really good job. Yeah. So can you talk a little bit more about what the role of an amicus is and what the briefs do with respect to the litigation?
Yeah, I'd be happy to. Amicus briefs can serve a whole different variety of important roles in litigation. And for those who don't know, amicus briefs, it's a fancy word for these what are called friend of the court briefs. And these are briefs by people who are not parties to the litigation, right? So in these cases, you're not either the FDA or the tobacco company that's suing the FDA, but other parties. And these are other organizations like Public Health Law Center, like the Campaign for Tobacco-Free Kids, the American Medical Association, state attorneys general, right? That have some sort of knowledge that they can bring to bear on this litigation. And how I like to think of it is the amicus brief needs to add something to the litigation that's not already being said, right? No judge or law clerk wants to read a repeat of the briefs that the parties have filed. But can we educate them about something else that's going to help them understand the litigation better, right? So for example, Kyra, you talked about the deeming rule cases in the past, right? Well, one of the interesting things about the deeming rule cases is they started to come up before a lot of people even really knew about Juul or vape products, or that there was such a huge sweeping amounts of youth among young people, right? So pretty much you can have this whole legal discussion about whether it was within the FDA's discretion to move the deadlines or X or Y or Z. But did your judge even know what you were talking about or why the FDA would do it? And so you can provide a little bit of that background. Also, groups like the Public Health Law Center and others have often been involved in crafting the legislation, like the Tobacco Control Act and things like that are at issue. And they can give the court a broader overview of the whole scheme, a whole legislative scheme, right? So we're not just talking about this one provision about the special rules about menthol, right? But can we give the court a bigger picture of what Congress was trying to do? Now, of course, we don't just, pontificate about what we think Congress was trying to do. We're supporting it with the text and all of the documents, but can we give the court a bigger picture of the provisions that they are understanding? So sometimes amicus briefs are more on the science and explaining, why are these regulations really important? What are these products and things like that? And sometimes it's more on the legal angle and trying to really explain to the court how the whole scheme works together. Maybe understanding some of the history of tobacco control so they can understand how the TCA wasn't meant to take away all of that state and local government authority. These are other perspectives that I think the Public Health Law Center and many other groups can often add to the court and can be really helpful for the court and the law clerks and people to know. I think we're fortunate. We often see things that we write in briefs come up in the opinions because we're doing some of that hard work for the law clerk and for the judge, and whether it's the background history or the statutory scheme or things like that help them decide cases.
This is kind of a follow-up question, but as a clerk, did you ever encounter any really impressive amicus briefs that kind of?
Yeah, I mean, amicus briefs, they can, yes. I mean, and when I was clerking on the Supreme Court, I mean, there were times where the parties were arguing the answer should be A or the answer should be B. And an amicus brief would come across and say, no, actually the answer is C. And the justices would agree with C, or, would kind of add a different perspective. Now, sometimes amicus briefs can also be effective when they're just showing support for a position by people who you wouldn't expect that support would be from, right? There's kind of what we call unusual bedfellows. And you can say, even the military is weighed in to support and say that we shouldn't get rid of affirmative action because diversity is a very important value and how it may impact the military. That's something that is a little unexpected, right? And might make people think differently about, okay, well, what is the importance of this rule? And therefore, how do we do the constitutional analysis given compelling interests or things like that? So I think they can serve all sorts of uses, and people read them. There are some judges who don't like them as much as others. But I think for anyone, you should coordinate with the other people who might be writing amicus briefs, so you're not all just writing the same thing and somebody saying, oh, I already heard this before. But if you coordinate and strategize, you can really be adding lots of interesting new perspectives that the court might not otherwise be getting. And I should say too that the amicus briefs don't need to be a treatise. It doesn't have to be super long. I think in the graphic warnings piece, is a bunch of state attorneys general filed a brief that was 10, 15 pages and made just like one succinct, really important point. Like, our constituencies don't know these things, right? And it would be really important for them to be educated about them. And that can be really powerful to say, hey, there really is an interest here that supports these warnings.
Yeah, those are really good points. And in the legal world, 10 to 15 pages is very succinct and short.
Yes, yes, I did. Double space, 14-point font,
And another question is, there are a lot of public health folks that are interested in participating in litigation or somehow influencing what's going on, but they may not necessarily be in a position to file an amicus brief. Are there other ways that public health people can participate in litigation?
Yeah, totally. Lots of ways to get involved. First of all, if your organization doesn't have resources on its own to do amicus briefs, you can always team up with other organizations. There's no limit to the amount of organizations that can sign onto an amicus brief. You can also provide all sorts of data and evidence and information that would then go into the amicus brief, right? Just because you're not leading it or, kind of funding it or deciding to file it and writing it yourself, right? You can still really contribute to it and share a perspective. Other ways that groups really in the public health community in particular have gotten involved, and this is well beyond doing amicus work, is they have been parties in these lawsuits, right? Public Health Law Center, you guys filed citizen petitions that are now at issue in the California lawsuits about menthol. Public health groups, the American Academy of Pediatrics and other groups, sued about the deeming rule and the delay of the deadlines for pre-market review. People sued about just this delay. The Campaign for Tobacco-Free Kids was part of it. This just delay in getting the new set of graphic warnings out again. It was like, how long were we going to wait till the FDA did this again, right? And so they can get involved that way. Sometimes groups also intervene in lawsuits, which is usually happens when you're worried that one of the parties, mainly the defendants, won't do a good job defending a rule. So if you're worried, for example, that a particular government agency is not going to defend a public health regulation, you can kind of intervene and stand in the shoes or in like shoes of that party. And that's another way that public health groups can get involved. But it's also important, I think, that groups can use their promotional materials and things like that to educate their members and their organizations about what's going on. It's the legal world can sometimes be difficult to understand and not as easily accessible to the general population as I think it should be. And groups, I think, play a role in telling the general public, what's going on, what are our courts doing, why is it that we don't have graphic warnings like other countries, and having people understand the legal system, I think, is really helpful.
Yeah, that makes me think when AATCLC and ASH first filed their lawsuit, they held a press conference, and I think they've done a really incredible job of spreading the word about what they're doing and why it's important, and getting that sort of like general public support is really helpful in kind of telling the story.
Yeah, and if you are not aware of the history of the practices of the tobacco companies, and if you're not aware of something like menthol or flavors and how they're used to target kids and how they're used to target particular minority groups and things like that, you might just think, oh, well, why should we worry about menthol? People just can choose whatever they would want to smoke. They want to smoke menthol, they want to smoke normal, whatever. Why should we care? Why should we support our government's decision to require the FDA to study this, and the FDA, if it decides, to ban this, right? Is this really about a free choice thing, or is this really about, a whole history of systemic targeting with an addictive product? And that education, I think, helps us understand much better the decisions that our government is making, and allows us to hold our governments accountable and to make just better informed choices as citizens, but certainly as public health groups advocating in this field.
I think too, during the rulemaking process, even before any of the litigation happens, submitting comments is really important.
Totally. And many public health groups, states attorneys generals have submitted comments. Cities have submitted comments, and how is this rule going to impact us? And that's a really important perspective to get out there. And it's important. We can be, I think, sometimes cynical about the process. Oh, they're going to do what they're going to do anyway. But the administrative process is actually quite meticulous and painstaking, and they have to respond to comments, and they have to think about evidence that's put before the agency, and you can really help an agency understand your group's perspective and the knowledge that you have through comments other advocacy like that.
So I think we will open it up to Q&A right now. I think we have one question. Are there reasons that the FDA is not acting on menthol beyond raw politics? Good question. I mean, I think the politics is a huge piece of it. I would have to defer to, and I'm not sure if you know more about this, Rachel, but defer to my colleagues in terms of like what exactly happened in the early days of kind of when the public health groups submitted their petition. I think the agency is kind of hidden behind this idea of like, well, we need to consider all these other potential issues and what about illicit trade and blah, 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 to kind of like paint this picture of there being a lot more question about public health harms than there are, yet at the same time it's issued its own report concluding that menthol is damaging to public health. The TIPSAC report came out. There's an overwhelming mountain of evidence showing that menthol's removal from the market would benefit public health. I would have to think that politics has a lot to do with it, and I don't know, agency inertia generally.
Yeah, I think, it's always hard to know unless you are in the agency itself. And my husband worked for some time at the FDA, so sometimes I got a little bit of a glimpse. But I think, politics certainly come into play. I think there's also such a huge amount of litigation that happens in this space, right? The FDA probably knows, and I would imagine, thinks that whatever they do, they are going to get sued by the tobacco companies. And well, there's a track record for that. And so they really, really want the evidence and the I's dotted and the T's crossed. And I, as an attorney and an appellate attorney who, try and be very meticulous with my work, totally get that. But at the same time, the standard in the Tobacco Control Act itself is not, do we know beyond a reasonable doubt that banning menthol overall would be helpful to the public health, right? Do we, the standard is not, is there undisputed evidence, right? There's always going to be one study that comes out and says, the other thing that, sugar is totally fine and go for it, or whatnot, right? But there's, and so I think the question comes up as to, how much evidence do you really think you need, or how much evidence do you think that the statute requires? And, my sense, like you said, Kyra, is that the evidence here is really quite overwhelming. Some people might say there are some reasons not to prohibit menthol in cigarettes because maybe, for example, there might be a black market is a big issue that the tobacco companies are pushing right now, and things like that. What the FDA does is it weighs benefits and consequences, right? I mean, that's what Congress and a lot of lawmaking is. I think, without getting into the details about these illicit trade arguments and things like that, the fact of the matter is we do vest our agencies with the expertise to look at all these studies and the research to make these decisions. And they have thus far said overwhelmingly that it would be beneficial for the public health to add menthol to the special rule. So, I think probably what's holding up at this point is it's more political.
And yeah, I guess the fear of litigation piece is really important too, and kind of underscores why it's so important that these public health groups have been filing their own affirmative cases to push back, just because we know how litigious the tobacco industry is, and FDA knows how litigious the tobacco industry is, and until the past, half 5 years or so, that wasn't necessarily the case when in terms of public health groups suing the agency specifically. Certainly, there's a lot of examples of AGs suing the industry and the government suing the industry generally, but or the federal government. But yeah, sometimes it's just necessary to have that like yin and yang.
Totally, and that's why the AATCL suit right now, the menthol suit that's out in the Northern District of California, that is putting that pressure on now and saying we can't just sit for how many years. We are now, it was 2009, right? So we are now quite a ways out. We're a decade out from the Tobacco Control Act, and menthol was really singled out in the Tobacco Control Act. Congress said, right, like, go study this. We're not 100% sure. We're not going to include it in what we do, but go study this, revise this, see what you find. And it really didn't, I don't think, single out any other products or things like in that way. So this should be quite high on the FDA's list. It had a mandate from Congress to do so. And that's why I think this suit is particularly salient.
And again, thank you so much, Rachel. We really appreciate you taking the time, providing all of your expertise. And again, for those of you who haven't taken a look at the amicus brief that was submitted in the 2 graphic warning cases, those are available on our website, and I would definitely take a look at those in addition to the other amicus briefs that are also on our website. So, thanks so much.